Can a minor child remove a restraining order that has been imposed on one of his or her parents by the other parent? And if so, how? This is a great question. My answer will disappoint you. I answer your question based upon the law and my experience where I practice divorce and family law, Utah. In my experience, courts that handle domestic relations cases, like divorce, and that means district courts, I'm not including juvenile courts in this group, they hate to hear from children, even when the children are the subject of the lawsuit. Courts will inexplicably and, in my opinion, inexcusably bend over backward and tie themselves up in knots to ensure that a child does not testify directly to the court on the record. Instead, courts will appoint a guardian ad litem, a GAL, and or a custody evaluator for the weird and counterproductive purpose of deliberately obtaining secondhand information about the children's experiences, observations, opinions, and preferences, rather than getting them directly from the children themselves. If a child seeks to intervene as a party in a child custody case because the child wants to have a voice and have some control over his fate, the courts will do everything in their power to ensure this does not happen, even though the laws on the books permit intervention by a minor in the very case of which he or she is the subject. Now, I've overstated the point a bit, but just a bit. The excuses that the courts will give for refusing to allow children to testify and participate as a party in cases involving disputes over custody of that very child or very children are essentially, children testifying and participating as parties unduly traumatizes them. While this could be true of certain children in particular cases, treating every minor child who now exists and who will ever exist in the future as though they will inexorably be harmed by testifying on the record and or participating as a party and or unduly or irreparably harmed by such involvement is, with due respect, obvious utter bilge. Such determination should be made on a case-by-case basis. So if you're a child who wants to come to a parent's defense and claim that the restraining order that the other parent has obtained against your parent is bogus and or unnecessary, good luck with that. You're going to need it. A lot of it. Because I don't know how you'd ever be able to win such a battle as a minor child. Believe me, I've tried. And so far, I've failed despite my best efforts.